At present, there are 8 FIRs, but first we have to talk about the main speech because of which all of this started against him. So this speech was delivered on 16th of January 2020 in AMU when he was called there by students in AMU. He had gone there, given a speech. There were not more than 20-25 students there. He gave the speech before such a small crowd there, and somebody must have uploaded it online. It eventually garnered attention on 25th of January because that's the day when he shared a 39-second clip on Twitter. Somebody had posted there, and in that clip only a small portion of the over 1 hour 10-minute speech was there, in which he was asking for a complete roadblock in the northeastern states. So immediately, without understanding the context of that statement, without trying to even go through what he's saying there or where was this speech delivered, what was happening, immediately 5 FIRs are registered in 5 states: Delhi, UP, Manipur, Arunachal, and Assam. And by the 26th of January, that is within 24 hours of this tweet or this part of the speech getting viral, there are 5 FIRs against him, and he is declared as a secessionist across media platforms. Everywhere, everybody is talking about Sharjeel as somebody who is anti-national, anti-India, and things like this.
The 5 cases are charged under UAPA.
In the Delhi FIR, UAPA sections were there. No, in the Assam and Arunachal, UAPA sections were there. Apart from that, there was no UAPA section in any of the FIRs. Mostly the FIRs were registered under 153A, 153B, 195. These are all sections where which are there for hate speech, essentially. So UAPA was in Assam and Arunachal Pradesh, and interestingly, these are the 2 states where charge sheets were not filed even after arrest, and so he got default bail in both the places. UAPA sections were added in the Delhi FIR on the 88th day of his arrest, and this is important because within 90 days one has to file the charge sheet in normal offences. In UAPA offences, the time period is 180 days. So if the charge sheet is not filed by the 90th day, he would have gotten default bail like Assam and Arunachal. But because because the section of UAPA was invoked in the FIR, that's why the period got extended to 180 days. Apart from that, in Manipur and UP, no UAPA sections were invoked ever, even till date. So, yeah, that's it.
You're talking about 26th of
Yeah.
January.
So 26th of January, he's all over the media because of that speech which went viral. And on 28th, he surrenders. Basically, he spoke to me. He told me that he wanted to surrender because this whole thing is disproportionate and it was taken out of context. He wanted to explain these things, and that's why he wanted to join the investigation, get himself arrested if that was required. And that's why he contacted me. He told me that I want to appear before the law and I want to surrender before the Delhi police. So he was in his hometown, at his home only. The police had not gone there in his search. But everywhere in the media, it was being shown that he has absconded, he has run away. So I go there to his hometown, and while we were coming to the airport on our way back, we are intercepted by a team of Bihar police, and then they start thinking that what can be done now, because there was no FIR in Bihar. So then he's shown arrest there and he's taken to the local magistrate, and then the next day he is brought to Delhi, and on the 29th he is arrested by the Delhi police formally.
What happens to Sharjeel later on became a pattern where, there'll be a social media clip to
Yes.
start with, and that subsequently ends up in an arrest under UAPA charges.
Yes.
Can you explain how that pattern actually started working, and how did this Sharjeel Imam, who gets arrested on 28th of January, becomes a mastermind of a pogrom violence
Yes.
that happened
Next month.
a month later?
So, as far as this pattern is concerned, before going into what happens in this pattern and how it's done, it's very important to understand that UAPA sections being invoked in a speech is very unusual, because UAPA sections are essentially for the punishment for the terrorist acts, and the section 15 of the UAPA explains what a terrorist act is. A terrorist act is some act which causes such immense threat or danger in the eyes of public at large that it even tries to overawe the government of the state. So something of that nature is generally used to be considered as something that is a terrorist act, and all the sections which are invoked against him or other people in this case is also such acts which were earlier invoked, where there used to be bombing or mass killing or things of such nature, where the security and integrity of the nation is compromised. In this case, if you see that the whole idea of arresting him, I'm only speaking about Sharjeel, the whole case against him are the speeches he delivered. There is nothing against him apart from these speeches. And even if you go through the speeches, they are taken completely out of context for the purposes of this prosecution. Because in his speeches only, we have highlighted it and we have repeatedly mentioned it before the different judges also, that in his speech, at least 15 to 20 times, he is asking the people to not pick up arms. He is asking the people to be there, and there'll be instances where you will be beaten by the police, but you have to stand your ground. You have to be there. You don't have to take the violent part. And then a statement comes in the speech which is completely not in consonance of the other portions of the speech, where he says in a joking manner. If you see that video also, where which was circulated, he is saying that असम को काट के अलग कर देना होगा, इतना मवाद डालो कि कोई जा ही ना पाए, जाने दो उन्हें एयरफोर्स लेकर, एंड ही स्माइल्स आफ्टर दैट. So the main prosecution which has been initiated against him in this case and the other cases, which all originate from the speeches, they are all baseless, because no investigating officer has applied his mind to understand the context, and honestly no judge has given a thought as to what happened after the speech, because there are a number of judgments of the Supreme Court which has explained what terrorist act is and what is actually to be seen in case where sedition or UAPA provisions are there. Over a period of time, it has all been diluted. The sedition law was so colonial and archaic that it had to be repealed, and there is a complete stay on the sedition law. But the problem is that exactly the same provision is there in UAPA for unlawful activity, and now only the police has to register the FIR. Apart from sedition, they have to mention UAPA. It becomes more stringent than sedition, and in sedition there was punishment 3 years up to life, but in UAPA there is no punishment which is less than 7 years. So it has not really helped the people, but it will subsequently be understood that this is a big problem, that the same provision has been incorporated in the UAPA, and now more and more people are being charged under UAPA. Honestly, the invocation of UAPA should have been restricted to only offences which can actually fall under the definition of terrorist act, but that is not the case, unfortunately.
Uh, in terms of this irrationality of, like, him being arrested, and he's been implicated in a case later on, for an incident that happened while he was in judicial custody.
Yes.
What is the prosecution saying, and how are you challenging that prosecution?
So, to that, the prosecution must have understood that it won't be possible to implicate him if he's one for the past 1 month he has been in custody. So the prosecution has brought up a whole new story that the conspiracy for the riots were in 4 stages, and the first stage was in November when CAA bill was passed and this Babri Masjid judgment had come.
December the CA bill was
Yes. So November the conspiracy started. In December they fructified and they started this Shaheen Bagh protest and small protests across India. In January, more and more such protest sites were started, and these were the people who were mastermind behind those protest sites. And in the fourth and final execution stage, the riots were to take place. So this is how the prosecution has made this story, saying that it was done in 4 stages, and because Sharjeel was arrested in the third stage, he could not actually physically be present for the fourth stage, but he was a part of the conspiracy. And now the funny thing about conspiracy is that this section 18 of the UAPA, this is the punishment for conspiracy to commit a terrorist act. Now, when you say that the prosecution is required to show evidence of there being any conspiracy, the prosecution comes back and says that it's impossible to find any evidence of the conspiracy because it's a common knowledge that conspiracy is hatched in secrecy. So, by the acts, at least they should be able to show anything. In this case, if you see that not only he was in custody for the past 25-26 days before the Delhi riots took place, he had never been in touch with any of the co-accused persons in this case, not even Umar Khalid. So the prosecution story says that Umar was his mentor and he was following the directions of Umar Khalid to start these protests. Somebody who knows Sharjeel personally would know that his ideology and Umar Khalid's ideology are completely different. They never interacted even when both of them were in JNU. They had their own ideological differences, and this story that he was his mentor, he was his prodigy, whatever, everything has to be established by the prosecution. It cannot be the case that they come and say that look, these 3 people were working in conspiracy, but there is no evidence because obviously conspiracy is hatched in secrecy. If there is no conversation between the 2 people, if there is not even a single message exchange between them, if there are no common groups between these people, if they have not interacted through social media platforms with each other, it has to be taken as an evidence that they were not in touch. Then how can there be a conspiracy? Not only Umar Khalid, Sharjeel is the only person in this whole case who had no interaction with any of the other co-accused persons. So these things should have been seen by the prosecuting agency, but that is not the case here, because if you see the charge sheet, I'll show you the charge sheet. In the charge sheet, the whole story has been written as a novel, and only flowery words are used, and as a defense counsel, I can tell you that a charge sheet is the result of the investigation. Whatever the investigating officer finds during the inquiry or investigation, he compiles it, all the documents, all the statements, and then on the basis of the evidence, that is the documentary evidence as well as the oral evidence, he gives his opinion that on the basis of such and such facts and documents and circumstances, I believe that this is the case against this person and these sections can be invoked. So that's how a charge sheet ought to be made. But in this case, from the very first sentence, it has been mentioned that Sharjeel Imam was an extremist who wanted to do something against India, and that's how he met Umar Khalid, and they both started doing this and that. It's like a complete story which they had already prepared, and they wanted to fit in a few evidences and the statements to make sure that this story sails through. This is the case how the prosecution has worked in this case. Also, I personally and very firmly believe that it is completely upon the police and the prosecution if they want to frame someone, if they want to arrest someone, if they want to let go someone. I'll give you a simple example of the BJP MP from UP against whom the Wrestler Federation of India guy Brij Bhushan. So Brij Bhushan was charged under POXO offences. Section 10 of POXO was invoked against him. Investigation was going on, and during the investigation he was not arrested. So a lot of people were questioning that how and why this was done. POXO offences are serious in nature. He should have been arrested. But it is a complete discretion of the police officers, because if the police officers have to show that somebody is required for investigation and interrogation cannot be possible if he is not arrested, then they have all the rights to arrest that person. If the same police officer thinks that no arrest is required for that person, nobody can make that investigating officer arrest them. So it is a complete discretion of the police officer who is investigating the case. So it is not as if an FIR is registered against you, even if it is for murder, even if it is for rape or POXO, then you have to be arrested. It is upon the discretion of the police officer who is investigating the case. If he feels that it is required, because either you will not cooperate, you will run away, or you will not just be there for the trial, then he can arrest you. Otherwise, there is no mandatory requirement to arrest anybody. So what happens generally in India in the recent past is that if any Muslim leader or activist, or even a cleric for that matter, gives a speech which seems to be provocative, or if he gives a provocative speech, because we are nobody to judge whether something is provocative or non-provocative. It is even if one person feels that it is on divisive lines and this is communal in nature, and in that case he can get an FIR registered. Now the police comes there, and if the police feels that this person should be arrested, then they can arrest him. Then there are examples of other people who have given speeches who are not from the Muslim community. They have not been arrested in a lot of cases. There is the example of this Haryana sadhu Yati Narsinghanand. Then there are many others who are not arrested, and FIRs are registered against them, but this discretion has to be checked. And this is the main concern which I feel is there, and it's aggravating also, because there are so many cases where people from a particular community are arrested, and for similar offences there may be 10 FIRs also, people are not being arrested. So
For the time being, you have worked on different cases and especially on
yes.
UAPA cases. Do you see a racial profiling happening in terms of Muslims as a race have been profiled, and the charges have been aggravated?
Definitely, this has been the pattern, because I'll give you a few examples and then you'll also be able to relate from that. There's a case I've been doing, this was an FIR of 2018, where two Kashmiri boys were arrested in Delhi, and the allegation against them, the FIR registered against them was under section 25 of the Arms Act, because they were in possession of arms. And this was a gun which they had purchased from somebody in UP, and they were apparently trying to take it to Kashmir. So at best, the offense which could have been attracted was for Arms Act, having a gun illegally or without any permission, or that registration card, etc. When they are arrested, after around 40-45 days of their arrest, their mobile phones are scanned, and then their emails, and then their whole contact list is scanned. And one of them had spoken to somebody in Kashmir, and he had spoken about things like don't go there, army is doing search and cordon off operation is going on, and things like this. They clearly seem to be a little perplexed by the army intervention and search and seizure and whatever the cordon and search. This this is a very common practice there, and they are afraid by the army movement, and they are asking repeatedly that if you are safe, if you are fine, army hai ki gayi, and things like this. On the basis of this conversation, UAPA sections are invoked against both the people, both the boys. One of them was 19-year-old, by the way, at that point in time. Once this UAPA provisions are invoked, then now they have been in custody for slightly over 6 years, and the 19-year boy I am talking about, there is admittedly no evidence against him till date. He was using a keypad phone, so nothing was there from his phone. He had there is not even one statement of any witness saying that he was a member of XYZ organization or he was doing this for someone else. But the allegations now in this case are that these two people are ISIS recruits, and they had come to Delhi to purchase and procure sophisticated weapons for ISIS, and they were going to use this for terrorist act in Jammu and Kashmir, and they were held in Delhi. So 6 years and 2 months, both of them have been in custody, where this young boy, 19-year-old boy, who is now over 25, there is no evidence against him. So we moved an application before the trial court, it was dismissed. Bail application before the High Court was dismissed. Before the High Court, the counsel for the NIA had specifically mentioned that there is no evidence against him, but he was in company with the other person, that's why we charged him for this offense. The High Court bought this argument, and in the order it has been mentioned that any sane person, any law-abiding person would not be feared of the army movement, and because he was with the other person who was in touch with someone in Jammu and Kashmir, that's why he is also arraigned as an accused in this case. Now we have filed an SLP before the Supreme Court. The notice has been issued and it's coming up in November for final arguments. But the situation is so horribly bad for a lot of other people. Like there's another case where this boy who used to live in Saudi, every month he used to send some money to his family members through another person, and the person he used to send money for his father, mother, and other expenses, that person was a Maulana who got